Hello, everyone, and welcome. Thank you for joining us today. The webinar is hosted by Express Computer in association with Skyflow, and it's titled DPDP in Action From Mandate to Execution. I am Mansi Singh, and I will be your host for today's session. India's digital personal data protection rules mark a major turning point in our digital journey. Privacy is no longer just a policy document or a compliance checkbox. It's now an operational, architectural, and leadership responsibility. Over the next 18 months, organizations across sectors will need to rethink how they collect, manage, secure, and use personal data, especially as data becomes more deeply embedded into digital products and AI systems. And all of this has to happen while businesses continue to move fast, scale responsibly, and stay innovation led. That's really what today's conversation is all about. We will be discussing the newly notified DPDP rules and what they mean in practice for Indian enterprises, not just from a legal lens, but from an execution and engineering standpoint. With a phased rollout, tighter breach reporting timelines, clearer consent frameworks, stronger protections for children's data, and explicit accountability at the board level, DPDP is all set to reshape how data, AI, and digital products are built and governed in India. To unpack this shift, we have two outstanding speakers with us today. And before we get started, let me quickly run through a few house rules to ensure a smooth session for everyone. This webinar is being broadcasted live and is available on demand on our website. This is an audio and a video webinar. You can send in your questions using the Tech Q&A text box and we will address the same after the session. If you face any technical issues, please use the Q&A text box to send in your issues and we will try to sort the same to the best of our abilities. If any of your questions are unanswered, we will connect with you over email to answer the same. And now it's my pleasure to welcome our speakers for today. So firstly, we have Advocate Puneet Bhasin, one of the India's most respected voices in cyber law, privacy, and data protection. She is also an internationally recognized expert and honorary advisor to the United Nations Digital Public Goods Alliance. Puneet has been closely involved in shaping India's technology and data protection policy landscape, and she'll help us understand what enterprises need to act on right now from a legal and governance perspective. Joining her is Amruta Muktali, Chief Product Officer at Skyflow. Amruta brings a very practitioner led view to this conversation with deep experience in building AI driven platforms and privacy by design architectures at scale. She'll share how organizations can move from regulation to real execution by embedding DPDP compliance directly into the products, data pipelines, and AI systems without slowing down innovation. And this session will be moderated by Salvi Kotian, Assistant Editor at Express Computer. And before I hand over the dais, a gentle reminder to please share your questions using the Q&A text box during the session. We will be addressing them live, so do not hesitate to post your questions. With that, over to you, Salvi.
Thank you both for joining in. So, Puneet, so you come from you have all those expertise from our DPDP Act. So finally, the DPDP rules are now being notified with the staggered of 18 months of rollout. Can you summarize the biggest legal implications enterprises need to understand right now? One. Second, can you break down the key highlights of this newly notified DPDP rules and the big shift that Indian businesses must prepare for?
So the first thing, how businesses need to change their mindset towards privacy. That is something which the Act and the rules both envisage. So wherein, business practices, marketing practices have been aligned in a way that, monetization of data is more important as compared to privacy of data. So the Act and the rules primarily aim at enabling businesses to have a balance between the two. So, you cannot just randomly monetize data if it is not without the consent of the individual for what it is being utilized. Those principles of consent, principles of data security, all of those are coming into the picture because of the DPDP Act and the rules. So as a lot of businesses even now believe that, oh, this is some form of a draconian system which may curtail their businesses, that is not a fact. Globally, as a matter of fact, usage of data left, right, center is definitely not allowed. In India, it has been like a free field for everybody. So I think that's why a lot of MNCs love doing business in India in this space, especially tech companies, because we have a huge population, diverse data, and we had no laws pertaining to data. So this was like make money as much as you can, make hay as while the sun is shining. But obviously, everything has its time, and the misuse of data, the you could say repercussions of this form of data monetization happening indiscriminately are very, very dire. As a matter of fact, not just to individual security and life the risks exist, but also to national security. It's in the light of this that the DPDP Act and the rules that come in. And for businesses, it's a very, very simple compliance wherein they need to go ahead and balance the two things. It is not difficult. It is not impossible. It's just that they're used to not doing it. So it's like, aaj tak kabhi kiya nahi, aaj kisi ne bol diya kar lo. So then you feel that pinch. So that pinch would be there for some time, and then soon business practices would be aligned to ensuring and respecting the data rights and the data preferences of the customers.
Wonderful. So, Amrita, from the technical standpoint, what part of this newly notified DPDP rules do you believe will be the hardest for the Indian organizations to implement?
Actually, I like what Puneet said, right? It's not about being hard. It's like you've never done it before, so it may seem hard to you. But it's actually, I don't like to think of like the technical safeguards are hard. The only thing that, so Rule 6, right? Rule 6 talks about reasonable security safeguards. What is that? That's making sure you have all of the personal data encrypted, tokenized, you have the right access controls, you have visibility on how it's being used, what's happening, similar to the consent stuff that Puneet mentioned. There's compliance, right? Now, if you think of all of that, it's not that difficult to do. The difficulty comes from the fact that if you've not thought of any of this from the beginning, your architecture might be very diverse. You may have a lot of data sprawl everywhere. So first trying to figure out where is all my data might seem very daunting and overwhelming for people. So that's usually where you start. And then once you know that, then you want to get into like centralizing, because that is the easiest way. And that's why the vault and everything exists. There is a precedence with the Aadhaar vault or the PCI data vault, if you think of it, right? How you control the data, how you use the data, and it's very similar. So the difficulty comes from the fact that if you've had legacy architectures, you've not bothered about this, you have data that's just flowing everywhere, you have no clue where it's getting used, who's using it, where it's going. That makes it very difficult and overwhelming for people to actually tackle. Because with the reasonable safeguards, the other thing people think is, oh yeah, I can just say I have reasonable safeguards, but that's not enough, right? For regulators, it's like accountability. Like, how are you showing me that you have reasonable safeguards? Like, you can't just say you have it. You have to be able to show it. There's logging, there's auditing. Every action needs to be logged. So I think that's where the difficulty, like if you use the word difficulty, that's probably where it comes from.
Wonderful. So, Puneet, ma'am, legally, what do you believe Indian organizations struggle the most, since you are one who is more close to the enterprises, you speak to them more often, and in terms of consent, notice, data retention, and breach reporting. So where do you think they struggle?
So let me come to the first part before they come to consent and all of that. In India, the concept of compliance, as what I say, has been, there are two forms of compliances that have been happening, unfortunately, because compliance has normally been out of the purview of litigation. Under the DPDP Act, failure to comply and all of that has ramifications in criminal litigation under the IT Act. That avenue is always open for individuals. Additionally, the one which is there with respect to penalization, which is there under the Data Protection Act itself, where you can approach the Data Protection Board for that to the tune of crores of rupees. So, there is litigation linked with non-compliance, which is something in India, non-compliance, okay, only if a regulator pulls you up, then probably there's a penalty. But for people to bring up their cases, litigate, hold you responsible, can initiate criminal proceedings, can initiate civil proceedings, that has not been something, most other compliances having precedence. So non-compliance means a regulator or certain government bodies, like in taxation, the government body will pick you up. You will not have an other individual coming and accusing you have done something like this and filing a criminal litigation. So that compliance concept in India differed. Today, DPDP Act brings a compliance concept where the board can also pick you up, regulators can pick you up, individuals who have been wrong can pick you up criminally and civil, in the civil fashion also, and seek penalty and seek compensation and do everything. So you are exposed on multi-fronts over here. That is exactly where the compliance changes. Now, in that, there are two parts. In India, till now, when we had compliances, there were two ways of compliance. Very simply, I will put it on a very practical methodology, how it happened. One was a chai samosa compliance, is what I call. So on paper, there is a compliance. The auditor comes once in a year. There is chai, there is samosa, and he signs off. The second method, the companies which are having better budgets, the PPT compliance. So the compliance is on PPT, very fancy PPT, suited, booted, all of that is the compliance. But actually, it is not there at the ground level. Now, it worked quite well because until and unless a regulator really picks you up, which is a very remote chance, not like you could say less than a 2-3% chance, that you would end up getting implicated. Now, under the DPDP Act, you have a multi-front exposure. And unfortunately, when you're dealing with a litigation, civil and criminal both being pursued, then it is all based on evidences. It is like a proper court proceeding. The chai samosa compliance won't work. That fancy PPT, honestly, no judge is going to care about. Nobody gives a damn. Anything mentioned in that has to be backed with actual evidence, needs to be corroborated, and everything is questionable, cross-examined. So that is where the major shift in our country happens. So consent is not the problem. Believe me, consent, organizations can practically do it. Going ahead to have data breach policies. In India, most companies claim they have a data breach policy. But that data breach policy is primarily a cut, copy, paste policy, which is coming from somewhere or the other, actually not implemented on ground or implemented very, very sparsely on the ground. So the mindset in India, we have data frameworks, we have consent, we have data breach policies, all of these on paper. Because that is how the compliance system worked. PPT compliance worked. You will show the board, oh, this is the compliance, a very, very fancy PPT that is there. And some checklists, some things in the organization shown, and it worked. So for many people, it worked. Spend a bomb, get a fancy PPT, and it worked. Now, when you are exposed to litigation, that is where it does not work then suddenly. Because you're not impressing upon a board. You are looking at police officers, you're looking at judiciary, which is not going to really care about a PPT. So that is exactly where I think the major challenge for organizations will come, changing their compliance mindset. Consent, breach management, all of that is there on paper in organizations. If you will say, I see a lot of organizations being able to defend it in a court of law, they're far from that at this point of time. So that concept of compliance has to change. We are very used to that compliance over so many years for multiple subjects. DPDP compliance has come now. But before that, there is so much of corporate compliance that happens. And it has honestly happened in this model only, the corporate compliance.
Wonderful. The compliance needs to be changed. So, Amrita, what is your take here? And also, organizations are still in the early structure of privacy engineering. What gaps do you see? How Indian enterprises should collect and store and share personal data?
I think compliance, like Puneet said, shouldn't be a checkbox. It is like, okay, I have it. I've done this, and I'll sign 10 documents or something, and I'm good. So I think that is the first thing that needs to change. Now, technically, if you go look at what needs to truly change, it goes all the way from collecting the data to processing the data through your workflow. as you're collecting the data, you want to make sure the consent and all of that stuff is there, right? The data is encrypted. Now, as it goes in, you want to make sure it is tokenized, obfuscated, centralized. You have your access control. So you make sure that the right person is given access for the right data, most importantly, for the right task. And when you give this data, you are auditing it, you are logging it, so you can prove that the right person has gotten that data. Then you get into like analytical, and I'm not even going to get into AI workflows yet, because that is a huge can of worms that people are not even thinking about right now. So when we think of compliance, I think there is one aspect of first figure out where your data is. Privacy first architecture is something you always want to do, because if you do a privacy first architecture, then it helps you move faster on innovation, because then you don't have to think about all these things, right? You are just like, okay, I've done it now, I don't need to worry about it, I can move so fast. So it becomes a for a lot of companies, they can move faster, it becomes a differentiator for them. So I usually think of compliance as a value add, as a differentiator. Whoever gets there first or does it the right way gains customers' trust and can innovate on their product faster. So I think everyone should think of it that way. It's like I always use this example of when you're driving, the cops tell us to put a helmet and a seatbelt. I mean, we all hate doing that. And that doesn't mean that they're telling you to do that and not do it, but that lets you go fast. Once you do that, you're going fast, and because you're staying safe. So it's something like that you want to think about.
Wonderful. So we do need to think about AI, Puneet. So, as Indian enterprises are aggressively adopting AI, chatbots, automation, and, now agentic AI, internal co-pilots, will DPDP change the way these systems are built and deployed going forward?
No, obviously they are supposed to change it prior itself. It is just that, the companies marketing these AI products are marketing them very well. Companies are made to believe that, they are going to increase their productivity, whatever may be the models that are working at this point of time. So ideally, the DPDP compliance has to come prior to you adopting any of these models, because it has to be aligned with your data governance framework. Eventually, see, a company is going to sell you a product of AI. However, you are answerable to the data protection board and to every other individual also whose data you are processing. In every other way, you are legally answerable. So ideally, you need to have your framework, you need to deploy your technical tools for data protection. You need to ensure that, you are securing, mapping your own data first. You are securing your data processing. You are basically having technology to support data rights management also. Consent management will come at a later stage. Consent you need to have, but as even the rules mentions that there is a timeline by which right now you're not expected to really implement consent management. But you need to have certain safeguards and certain internal frameworks already there. Frameworks doesn't mean paper frameworks. Frameworks meaning actually on ground systems operational to support those. So you need to have that at this point of time. Now, when you are adopting AI prior, so one thing you need to understand, when you're using multiple technologies of AI, there are already multiple disputes going on in so many judicial forums on you could say IPR disputes pertaining to data usage by AI models. I'm sure everybody has heard about those. There are certain leading disputes happening with leading AI companies and other MNCs and companies on wherein there has been, even if you would have seen that even in India there are these disputes happening in the High Court at this point of time, wherein there are serious IPR concerns that AI models and platforms are going ahead without consent to access data in order to be able to train themselves and further generate the results that are required. Now that raises major concerns, and an organization in the name of productivity going ahead and deploying this prior to having their own data governance framework implemented is actually exposing itself to a complete risk. So having this model deployed with respect to AI in your organization and as an afterthought doing DPDP compliance is actually a futile effort. Because you need to first do this and then think about AI. AI is a very nice buzzword. I do understand it improves productivity. I'm sure many of you have read about the case where I don't know how many dollars worth of PPT report was created via AI, and one company had pulled up the organization which provided them that report. So you can imagine the kind of level of work AI is doing to be able to create such complex reports also. So the work is amazing. But the challenge comes is that, let me give you the example of this very complex report which a consulting company had provided, which was, they were pulled up later that it was an AI generated report from ChatGPT or something. Now, even to prepare a complex report through these platforms, you need to understand they're pulling in data from multiple sources. Now, that itself raises multiple questions. So, once an organization is touching that regime, there are multiple challenges that come up. In India, we don't have an AI regulatory framework as yet, it is still in the pipeline. But yes, there are certain global best practices pertaining to AI which organizations at this point of time can adhere to. So, you can have your DPDP compliance, and simultaneously, when you're doing this compliance first, the best practices pertaining to AI deployment can be there in an organization, and both hand in hand would ensure that the legal liability is reduced.
Wonderful. So, Amrita, what is your take on these emerging buzzing technologies? And many Indian businesses rely heavily on the global SaaS platforms and cloud providers and third-party AI tools. How can they maintain the agility, innovation while adhering to the DPTP restrictions on cross-border sharing of the platforms? Also, how has Skyflow is helping them in this journey?
I think everything boils down to data. When you talk about using SaaS products that are either if made in India or they're, built somewhere else, what happens with these products? You are collecting data, you're generating data, you're working with data. So at the end of the day, whether you are using information, whether you're processing information, you're getting insights from it, it's all data. And when you have a data protection law, it applies everywhere. It applies wherever that goes, including like, we were talking about AI, right? That is the worst place that you can ignore it, because a model is like a baby with the memory of an elephant. Will never forget anything. So once the data is gone there is no way to delete it. Think about digital rights. How are you going to go into a model and tell it to forget something? A model cannot forget information today. So that is the biggest risk right now. And then when you talk about different SaaS products, cross-border data transfers, where is this data going? Because most of these SaaS products now are integrating AI within their platform. And again, they're doing it for the right purposes, for workflows and things like that. But the companies adopting this need to understand that where is my data going? And if my data is crossing the borders, what am I doing for that? And that is where, the rule 6 actually helps, because then when you encrypt and you tokenize the data. So with Skyflow, what we do is we help companies identify where that sensitive information is, centralize it, tokenize it, encrypt it, and convert it into a format or obfuscated format that is not reversible. So you cannot take that token and figure out what is the real data behind it, but you can operate on that data because it looks like the real data. And now what this enables is it does not block workflows. You can now take that tokenized information cross-border, you can process, you can do anything that you want. Even if you send it to AI, it can infer information, but it doesn't have the information. It doesn't have my Aadhaar number, but it knows that in this sentence I mentioned an Aadhaar number or something like that, right? So with Skyflow, what we are helping folks do is do that privacy first engineering thinking, centralize the data, provide those safeguards, the auditing, the tokenization, encryption, access controls to make sure that the businesses are not limited with respect to which technologies they can use, where they can send the data, and how they can actually accelerate innovation internally.
So, from the legal governance perspective, how should boards and the senior leaderships, CIOs, CTOs, or anybody in the executives should rethink the accountability under DPDP, especially in the organizations where data decisions are spread across IT, production, marketing, and AI teams?
See, the first thing is data decision cannot be split across so many bodies. There has to be one, you could say, a spoke in the organization responsible for the data governance throughout the organization. Yes, you could say stakeholders from multiple departments ideally should be a part of it. So even when I am implementing DPDP compliance in organizations, there has to be one responsible department. It cannot be everybody in the picture, because then it is actually just a haphazard system that is working. And that one particular department, which may be pertaining to compliance, data protection, or the CISO office, whatever may be the one department that is deployed, which is given this responsibility, because data protection involves not just your accounting department, it involves your HR department, it involves your vendor department, because data is there everywhere, including even your security department. Every single individual entering into your office complex was you are collecting at the entrance point. So there have to be, you could say, persons deployed, maybe one or two from each of these departments, who coordinate with the main office, either the CISO office or the DPO office or the compliance office, whichever is the deputed team in the company, for ensuring ground level compliance, to give information top up, to implement things top down. That is the model which actually is sustainable and workable. Otherwise, with data, it is impossible that, the way you asked me, okay, this is how it can happen, that all departments comply. That kind of compliance is okay when you're talking about ISO and all of those kinds of things. But when you're talking about something like data which is flowing everywhere, how much ever you may say, I'm going to put this in a vault, I'm going to do this, I'm going to do that. Eventually, one person entering through your door, giving their mobile number, and, I'm this person entering inside, in the watchman's registry itself becomes data. So the practical implementation eventually is going to boil down to an organized effort throughout the organization.
So, if you, Amruta, if you had to create a practical 90-day DPDP read lines checklist for Indian CIOs, CPOs, also CISOs, and product teams, what would that be on the top 3 recommendations?
I'll always say the first thing is discovery. First, figure out where all this data is, because it's everywhere, where it is being collected, what is happening, where is it being stored. So the discovery is probably the first thing you want to do. The second thing you want to do is, in some way, centralize the control over the data. It could mean consistent security practices, auditing, access control, governance, whatever you can. And once you know where the data is, it'll take time to do it, but that's probably the next step that you want to do. And then you want to put all those pieces around operationalizing consent and making sure you have, programmatic enforcement of things, because manually you can't do so much. And then you have rights management, you have DLP, you have all those things, right? So I think, those are the simplistic 3-step process, if you want to say, like 1, 2, 3, if you want to do. Not sure if everything is possible in 90 days. Step 1 itself might take 90 days, but that's what I would say.
So, Puneet, ma'am, your comment on 90 days, is it possible to create that kind of sanity in 90 days for the CIOs and CPOs? And what would be your 3 top recommendations?
Well, 90 days is a practical impossibility. Yes, a basic governance, data governance framework can be drawn up in consultation with the entire organization, the different departments, the different data flows happening. So that can happen within a 90-day framework. But if we are looking at complete compliance, actually on ground implementation with tool deployment, with proper privacy enhancing tools also there, proper documentation, data mapping tools, and actual documentation of data mapping, you could say organizational structure working towards DPDP, the consent actually not just taken but logged, the entire methodology of not just a paperwork compliance, but organizational implemented compliance, then 90 days definitely is impossible. But yes, a plan can be drawn up in that duration, because believe me, even drawing up the plan in, with all the stakeholders of the organization, especially if it's a bigger organization, itself takes close to 30 to 40 days. So that is something that can happen in 90 days. Well, to start the journey, I would say the first thing is start with data mapping. and start with a gap assessment of where is it that there are issues in your current data governance. So you may have something, you may be compliant on certain levels, but identifying where and what is very important. These are the two things I would say do right now. Start building your data governance frameworks. That would be the third one. So this is the way you need to start moving. And then obviously, as and when you are maturing in the compliance journey, you start deploying more, you start having more practices on ground, you have policies supporting them internally in the organization, and you implement the compliance. But the starting point has to be data mapping, gap assessment, followed by the actual DPDP compliance, building of the frameworks. Frameworks are built on paper, deployed on ground, and the frameworks on paper need to be deployable on the ground also. So all of those different structures are there. One of the other things I would definitely tell all CISOs and DPOs is make a genuine assessment that, what is the data you really want to collect. The best practice, the cost of data protection, one of the things I see organizations struggling thinking, oh, the compliance cost will be high, is because, as a habit, people have just collected data left, right, center. What you don't require, please don't collect, because see, every data set and data point is going to cost you money. So make a very, very recent decision of what is it that you genuinely require to provide services, which we call, there is a terminology itself in the DPDP Act where you are having a purpose limitation, and the purpose for which you're collecting that data, you're only utilizing it for them. So the moment organizations actually implement purpose limitation, they collect only data that is required and limit it to the purpose for which it is, and thereafter delete it. The entire cost of compliance will actually drop. Because then you're not looking at, let's say, 1,000,000 data sets. I'm just giving you an example. You're looking at 100. So it makes a huge difference. So that is the way you need to plan that, what is it I really require for a business practice? Then accordingly for what duration I will require. And then in the compliance journey, we need to ensure that we are not keeping data beyond that. We are not collecting anything beyond that. And that actually makes our compliance cheaper.
So, Amrita, your closing, remarks in actually getting these strategies more on the actionable part. How are you helping these organizations to operationalize the DPDP Act?
I think it's all the things that we've talked about today, right? So how we are helping is, first of all, as you're getting into what do I do here, helping people understand where their data is, where the information is the first step. Then how we are helping them is, once you know where this information is, let us help you collect, protect, and use. So we call it isolate, protect, and govern the data in the right way, right? And as you're doing all of these, let us give you visibility into what is happening where. So as Skyflow starts helping all of these companies, we are trying to help them think of compliance not as a burden, but just slowly start getting into it, and it'll start becoming an accelerator. So we are providing all the technical tools and safeguards. Now, there is a lot of other processes that a company is going to have to do in DPDP, because it's not just, it's like a three-pronged thing. It's legal, engineering, and product. All three have to come together to get DPDP compliant. And what we are helping them is with providing them with the frameworks, with the know-how, as well as the technology that can be seamlessly integrated within any architecture, whether you have a legacy architecture or you're building something new, whether it is transactional, operational, analytical, or an AI architecture. We are helping them protect that data across all workflows so you can be compliant.
Ma'am, your any closing remarks on making these strategies more actionable?
Well, it is actionable when you understand that, it's not just technology that needs to be deployed to secure data. It is individuals that need to understand the importance of technology preserving, working towards data protection, in organizations and frameworks working towards data protection, actual compliance, and the litigation geared towards data protection. Eventually, it's all about human beings. So even a company needs to be more humane towards their data practices, is what I would conclude as. Like, as an organization today, you are going ahead utilizing other people's data. Understand one thing: if you are not compliant, and the risks of data misuse are extremely high. So whether it may be cyber crimes or right to life and multiple other cases that are coming up, and your organization may end up becoming the cause of causing major disruption in somebody else's life. And eventually, even your organization is consisting of individuals. So, what you are doing with somebody else's data today, multiple other organizations are going to do exactly with yours. So you need to stop thinking like a company or a corporate with the capitalistic mindset of making money left, right, center. You need to think of it from a more humane perspective, that I cannot do something to somebody else's data what I don't want done to my own. So the moment every individual, whether it may be management, whether it may be mid-level or the ground level employees in organization, start thinking कि आज अगर हम उसके साथ ये कर रहे हैं, कर्म है, मेरा भी डेटा के साथ वही होने वाला है, I am also going to get subjected to something like this, because eventually everybody is in the same boat. So it is not, we are not a capitalistic economy. We cannot be ever, because our mindset in our country itself is more karma based. And I think that is a very good mindset to understand, because it enables compliance. Believe me, the moment you realize what every action has an equal and opposite reaction, every action of yours is going to have an opposite reaction which you will face, which is the law of karma. Automatically, compliance is very easy. So the moment organizations become more humane in India, stick back to their roots and understand this very basic principle, you will not do what you don't want done to your own data to somebody else's data. You will comply then.
Very wonderfully said, that stick to your principles. Thank you so much, Puneet and Amrita, for those thoughtful and practical insights. This discussion has given us a clear view on how Indian organizations can navigate DPDP with confidence. Thank you so much.
Thank you, Puneet and Amrita, for shedding light on this critical topic and for sharing your deep insights. And thank you, Salvi, for moderating such a thoughtful and engaging discussion. So we now open the floor for Q&A. Deepak Annamalai and Kalpesh from Skyflow are with us today to respond to your questions. Please feel free to share them in the Q&A text box. So we already have few questions.
Yep, I see.
So do you want me to take it one
About
by one?
20 questions. Now, let me pick some which is generally applicable for everyone. I think the general one of the questions was, where do we start, right? How do we start this entire process? And what are the major steps that they need to follow? I think we covered it, but just to summarize, I think it all starts with first, what is PII for your company is needs to be laid out. It will be different for a lending company versus insurance versus bank versus e-commerce. So it is important to list out what is PII either through your legal counsel or your DPO. So know what is PII for your company. And the first natural step is to know where the current PII is there, which database, which data lake, logs, reports. Know your data estate, where it is. Then you start thinking, how can I comply for Rule 6, which is the data security safeguards, Rule 3, which is consent, itemized consent. How do I delete data? How do I notify the data principal if there's a breach? For that, there are different techniques. One, you can keep the data wherever it is and try to protect it, govern it, or you can also bring the data to one central place, which is a very intuitive thing to do to solve for compliance. That also can be done. And then you set up a systematic process to handle the data day in and day out. Kalpesh, you want to take any other questions?
Yeah, I think there was one question here. Will this be applicable specifically to IT sector, or does it apply to all across all level of business? So the rule of the thumb is, if you're collecting any individual's data, doesn't matter what your relationship is that individual. He could be your vendor, he could be your employee, he could be your customer. The rule does apply to you. This law is not specifically for any IT or e-com sector. It does apply to all.
So another question, I think safeguarding must be initiated by building awareness among all stakeholders. Any different opinions? No, I think it all starts from that, like your leadership, your team members, some sort of a awareness program, like how Punit was saying, right? That it needs to be treated as if it's your own data. While that is the ideal state, at least start thinking that if the customer, anyone's data is compromised, then the accountability is now very clear. It was not there before. So bring awareness with the different stakeholders. Someone has to take charge in your company and do all these activities. But at the same time, if you are the one who's in charge of this, you'll also have to proactively engage multifunctional thing, not just team members, it's leadership, legal, IT, engineering. Everyone needs to understand the importance. And as much as you understand the importance of doing the right thing, it's also important to let them know if they don't do the right thing, what they are up for, like in terms of fines, audits, and then sometimes it can be very harmful for the business itself. So start with awareness, and someone has to be, if you're the one in charge, you should be the one taking it. If not, you have to find someone who's doing that.
Yeah. There was this another question. How are we ensuring DPDP compliance across all business units, especially in the sector like handling large volume of sensitive data, like finance and healthcare, and how does the approach differ from other sector? I think this is a good question. See, from the approach, before even we come to approach, one of the most important thing everybody needs to understand, the more data you collect, the bigger the responsibility gets, right? So you are a fiduciary, then you are a significant data fiduciary, so on and so on. And the laws also differ them differently because there are more stringent fines attached to significant data fiduciaries, right? So if you are processing data in large amount, your responsibility is quite high, and your approach should be, as Amruta said in the call, discover first, figure out where all the data is. Second point, put the controls in place, as Puneet said, that change your mindset of handling the data, put the controls in place, do the gap assessment, figure out where the gaps are, and put the right tools in place, privacy enhancing tools such as Skyflow, and there are other tools also which you are going to need. Put all of them in place as an approach, because if you don't do this, your liability is quite high on this one. It goes as high as 250 crores.
Yeah. So one another question, I'm already protecting my system with cybersecurity tools. What is different? So I think cybersecurity has always been there. It's in the olden days we used to have like even today, right? Like if you take our buildings, there is of course security guard, there's of course cameras, surveillance cameras. So those all are needed, like your firewalls, you're protecting your code, protecting your application. So those are all from a cyber security standpoint. Under cybersecurity, we are now going to the core of it, which is the data. All of it you are doing so that the valuables are not compromised or stolen. So in this context of DPDP, which is digital personal data protection, the name itself says it's personal data protection. So we have to go to the data level and make sure that you apply certain controls, which is explicitly called out in Rule 6, like encryption, tokenization, masking, so that even if the security guard is compromised, surveillance camera doesn't work, door is open, the person who's taking the data is still not taking the original information of the customers. So that's the level of attention and attention needed for the data in this point of time for the law.
There is another good question. In case of data stored on-premise but in proprietary system like SAP, where encryption and masking would not be possible, how an enterprise we can ensure the DPDP compliance? Now, there is no one straight answer to this, but let me tell you a couple of things. First of all, have a look at the entire architecture, and wherever you can implement the data controls, please go ahead and do that. Don't stop that I have two systems where I cannot tokenize or encrypt the data, so I'll not do the others. Don't do it like way. So first, make sure that everything else is covered as the first phase. Now, coming back to legacy system, you have 2-3 ways to look at it. One, you have to work with the vendor like SAP to put some mechanism in place, because it's a closed source software, so you will definitely need vendor's help, or you look at modernizing your stack and moving away from legacy. The second is a big lift, I understand that, but you will anyway do it when the vendor ends the support of that software. So we are talking to a couple of customers who are actually using very outdated software, which is nowhere supported by OEM anymore, but since it was working, nobody touched it. But I think DPDP gives you a chance to modernize your stack as well. And I'm saying this as an engineer, so now take it with a pinch of salt, but do think about this, that this is the right time to modernize the architecture.
Right. So, and extending that, right? Like there's always a bunch of system that you have under control. There's also a bunch of system where you can't control. At least the initial outlook, when someone wants to audit and find out, if there's any non-compliance, you have to show intent, right? If let's say for some reason there were two systems, you can't do it, and then you said that I'll not do anything, then obviously that will not go well with the eyes of the auditor. Whereas you can say that I have done so much, here is a process, I am on the way to do the other things, here are the challenges, then it shows that you have truly wanted to comply. So do as much as you can, but just don't stop just because you cannot do one specific system. But another two, three major questions are around hey, who's a significant data fiduciary? It's not clear. Yes, I think there's no full categorically saying that, okay, here are the 100 companies that are SDFs. But there has been some mentions in the act saying that, okay, if you're having huge volumes of data, or if you carry high sensitivity of the data, you typically fall under the SDF category. So think of if you handle, millions and millions of customer data, and let's say you handle more sensitivity data like PAN information, bank account information, health report. So naturally, the sensitivity of the data that you have is high. So those companies, and if you also have more volume, then you can treat yourself that you are a significant data fiduciary unless otherwise someone tells you.
Yeah. There was one more question here. Please share the DPDP Act PDF, and I hope that document that was mentioned how to implement the process. Okay. The act itself is available on the public domain. You can just Google it and take out the copy of the act. But let me set some expectation here. I have at least in my life not seen the act which says that you have to put this in place, then also explain how to put it in place. The how is always with you. The act never guides you how to do that. It is only telling you that this is what you need to achieve. How you achieve it, that is totally your purview, right? So we have options there. We can connect with you separately and tell you what options that do you have. And another another question which basically aligns to this is how about keeping the data in the region in terms of production and backup data. So yes, data sovereignty is part of the law. You have to keep the data within the Indian borders, unless you are part of some allowed cross-border data transfer, because there are some other laws which basically can come into picture into cross-border transfer, the treaties and everything. We may not have the clear detail on that, but take a rule of thumb. You have to keep your data inside India unless you have approval to take it outside, right? So you have to make sure all the data stays within Indian borders.
Yep. So the next question we have is, so what about data processor, right? So in the law, the liability is still with the data fiduciary. Let's say you are a company who's sending data to third party for marketing, like a MarTech platform or a CRM software. Now, if any of those systems are compromised, then the liability is still there on the data fiduciary, which is you. While it can be a huge undertaking, but it again comes, the law is always for the people, by the people, of the people, right? Like at the end of the day, the customer gave you the data, you chose to have a data processor to simplify your workflows. So now you have two options. You basically work with the data processor and get some contractual obligations from them signed up if it's not already done. Second, there is a modern world where today, like in the light of Skyflow, people are able to kind of generate tokens for the data, which is not original information, and then pass on tokens to the downstream systems as well as third-party data processes. And then only when they want to process the data, that is when they actually kind of detokenize and use the data, and they don't store it. So there are like modern techniques to solve such problems wherever applicable.
Yeah. Yeah, should the data fiduciary respond to request for correction, completion, or updating of personal data? Absolutely, yes. This is part of data subject access rights. So if you have collected data at some point of time and the data principal comes to you for correction, deletion, completion, or updation, you will have to comply for that request, and you also have to put a proper control or proper mechanism in place to enable this for the data subject. That means how that will take shape in the digital economy. That is something you have to figure out, internally, that how you want to deliver that mechanism. But yes, the law says you have to provide that mechanism.
Great. There was one more question. How we have to interpret security safeguards. So I think you need not interpret because the rules clearly calls out all the techniques that you are that is required. It's actually telling you that these are the kind of techniques you should use. It starts off talking about encrypting the data itself, or tokenizing the data, or masking, obfuscation. It talks about controlling access to the data. Then it also talks about how much you should uh, visibility you should have on who is accessing which data at what point in time. It's very clear. So there is no need to interpret separately, because it's very clear now that you need to follow these techniques, whatever suits best for you, holistically, and it also solve for it. And I saw one more question: does it apply to AI? So interesting question, because we all somehow think that AI is like a separate system on its own, but in the context of an enterprise, it is just yet another system, just like how you have a data lake or a database or a dashboarding reporting. It is just yet another part of it's yet another application which is handling data. And in the parliament also, it was called out that even AI comes under the scope of DPDP. So all the controls of consent, data deletion, encryption, tokenization, all applies for the AI models as well.
I think there is one more question. Companies keep data in different forms for security reason. Also, will it not be costly for such companies? I think don't look don't look at it a way as a cost. I think this is where we have to also change the mindset, right? We often think, if I put these four things in place, this is costly for me and it affects my business margin. Change that mindset and think, if I don't do this, what happens, right? If I don't do this and I get into some kind of litigation, I may actually go out of business, because the cost of uh, you know putting proper controls and taking proper data security measure will always be less than the litigation cost and the penalty cost. So I think one of the most fundamental shift we need to do as an Indian mindset, we need to first look it from the other way around, and not look it at the beginning cost, but look it at what it is saving you in future. It is saving you from litigation. It is saving you from reputational harm. It is saving you from monetary fines. So if you look it from that way, the investment you are going to make to put this digital safeguards in place for DPDP compliance, they will be very minuscule.
Yeah. I think one interesting question: what is how are we ensuring compliance across all business units, as well as what governance, consent, security controls are in place, right? Now, the general, I mean, this is what we want to kind of, from Skyflow's point of view, we want to share is that the data is everywhere. Uh, the traditional approach, if you say in the old times, building all security means, okay, let's build a compound next to near wherever we are staying, so we are more safer. But while that is good now, but today, as you can imagine, the amount of cyber threats, phishing attack, AI-enabled deep fakes. So a lot of people can easily get into a system through all these problems. So what we recommend is to, instead of trying to put a band-aid to this problem, try to fix the problem once for all, because of the other challenges that we have, where we kind of isolate this data to a central place, just like how we'll put our valuables into a safe box or a bank locker. And then that there's only one place to handle everything, be it data protection, data deletion, data consent management, data governance. It's always easier to focus one single place than to do it at 100 places. And then it's like building a fortress. Like, how do you build the fortress? There are technologies available, like vaulting technologies, that will help you achieve those end results.
I think we pretty much covered it all.
Yep.
Yeah, is the DPDP Act classifies same for all specific for our industry? Yes, there are some specific mention for some specific industries. You will have to go a little in detail into the law. But majorly, as I said in the beginning, thumb rule, if you're collecting data for any kind of individual, regardless of your relationship with that individual, the law does applies to you. So in that sense, you can take that most likely if you are correcting individuals' data, you are in purview of law. Now, as a specific industry, if there are any exemptions or any additions you have to do, that is something which is mentioned in the law clearly. I would recommend that you go and have a look at the entire law to get that kind of specific understanding.
Cool. I think
Yeah.
we're done with the question. Mansi, over to you.
Thank you, Deepak and Kalpesh, for those thoughtful responses and for bringing so much clarity and insight to this discussion. I really appreciate you engaging so actively with our audience question. And with that, we come to the formal close of today's webinar. Thank you once again, Puneet and Amrita, for sharing such clear, practical, and insightful perspectives. It was very timely and grounded discussion. What merely stands out is the DPDP is not merely about compliance. It marks a fundamental shift in how Indian enterprises must design systems, govern data, and build trust, particularly in an AI driven economy. And as organizations navigate the 18th month rollout, the real differentiator will be the execution, moving beyond interpretation and embedding privacy into products, platforms, and decision making at every level, from engineering team to the boardroom. We hope today's session has brought clarity to the DPDP rules and offered actionable takeaways for leaders across legal, technology, security, and product functions. On behalf of Express Computer and Skyflow, thank you once again to our wonderful speakers, and a big thank you to everyone who joined us today. We look forward to continuing this conversation as India moves from mandate to meaningful implementation. Thank you once again. Goodbye.
Thank you.